correct. Good afternoon, everybody. Brief introduction, my name is Stefan Schohe. I'm German European patent attorney, dealing amongst other things in the IT and software field. I'm following the case law for about 17 or 20 years. And I just wanted, as an addendum to Dr. Steinbrenner's talk, share a few comments on the situation in Germany. Why Germany, as Dr. Steinbrenner already mentioned, Germany is an important market in the EU. I would not say the most important, but it is an important market, and typically when you're doing business in Europe, you usually are involved with Germany sooner or later. The second reason is that next to the EPO, the German courts render the most decisions, and after following that, there are only some 5 or 6 report decisions from the UK and 2 or 3 from France. So when you've heard about Germany and European Patent Office, you know already most of what's going on in Europe, except perhaps for the British, but that's a different story I will not go into today. At the end of my talk, I might also comment on how things are handled in practice, and I may also get back a little bit to how examiners, be they at the EPO or at the European Patent Office, may handle things. With that a bit lengthy introduction, I would first like to give an overview, and the basic story is already, as Dr. Steinbrenner said, there is not so much difference, at least as to the... Oh, it's from the other room, sorry. I thought there was a question. I didn't expect it at this early stage. It's very similar as long as you consider the broad guidelines that were given by the Federal Court of Justice that comes close to the Supreme Court in the USA. Court structure is a bit different. We call it Federal Court of Justice or Bundesgerichtshof. However, it took a while until the Federal Court of Justice actually adopted this doctrine before we had other doctrines, and these still persist with examiners, with the lower courts. And what we really realize in day-to-day practice is people still think along the old lines, and they only adjust their reasoning to to the new guidelines of the Federal Court of Justice. Oops, that was the wrong way. As this may get relevant later on, I would briefly go in these traditional schools of thought, although officially they don't play a role anymore. The first is what we called in German the Core Doctrine, and was basically that the court or the examiner asked, what is the essence of the decision? What is the real invention? And what is just decoration, so to speak? And they didn't deal with the matter at all if they felt or if they concluded that the essential features are not technical or constitute excluded subject matter. Later on, this was modified in some decisions, not called the Core Doctrine anymore, but effectively being the same, that you only considered, you do not consider features that are somehow related to excluded subject matter at all, and only consider the clearly technical features, which, if your invention resides in software, basically is identical to just cancelling the software features. And you may note at this point that is diametrically opposed to the basic approach of the EPO, where they say, well, it's even if it is essentially non-technical, but there is some technical content, you have to consider it. So quite diametrically opposed positions. And then we have a thinking that's especially entertained by the Federal Patent Court, which traditionally was staffed with solid electrical engineers in their 50s or 60s that had little contact with computers during their university time, and this persists today, and they say, well, technical is only the hardware, or, well, we accept operation system, something that is really very close to the hardware at a very low level, that we will accept, but nothing else. So basically, when it was software, at least at a higher level, beyond the basic commands that control a processor, they said we will not consider this. Now, with this preamble, let's go to the Code Guideline of the Federal Court of Justice. And they have, in fact, three categories. They have technical character. For that, it suffices that one technical feature is sufficient, in so far identical to the EPO. With the exclusions, they request the solution of a concrete technical problem by technical means, and which is a bit different because before the EPO, just the presence of a feature was present, was sufficient. And then for novel inventive step, again, like in the EPO, you examine the technical solution to the technical problem. And when you look at the case law, the question is always, is there a concrete technical problem, and is it solved by technical means? Now, what is a technical problem at all? In this basic decision of 2010, the Federal Court of Justice said that the hardware approach is not proper. Of course, if you have features related to hardware, problem related to hardware, you're fine, but also software can be part of a technical problem that is solved by technical means. And in this decision, the court mentioned more or less exemplary